Be ready. 5 seconds.
The present batch of appeals bears on the distribution of legislative powers between the Union and the states on the taxation of mineral rights. Stop. The legislative entry which lies at the core of the present reference is entry 50 of list 2 of the 7th schedule to the Constitution. Stop. The entry deals with taxes on mineral rights subject to double quote any limitations imposed by Parliament by law relating to mineral development. Stop quote close. Regulation of mines and mineral development is enumerated under both the Union list and the state list. Stop para. Parliament enacted the Mines and Minerals (Development and Regulation) Act 1957 in exercise of its legislative powers under Article 246 of the Constitution. Stop. The MMDR Act is a code for the regulation of mines and development of minerals. Stop. Section 9 provides that the holder of a mining lease shall pay royalty in respect of any mineral removed or consumed from the leased area at the specified rates. Stop. In India Cement Limited versus State of Tamil Nadu, a 7-judge bench of this court held that royalty is tax and the state legislatures lack competence to levy taxes on mineral rights because the subject matter is covered by the MMDR Act. Stop. The court also held that royalty cannot be used by the state legislature as a measure of tax on mineral-bearing lands. Stop. Later in time, in State of West Bengal versus Kesoram Industries, a constitution bench of this court held that the decision in India Cement stemmed from an error and clarified that royalty is not a tax. Stop para. The learned Attorney General for India, made the following submissions, para. The grant of permission to undertake any activity in relation to a mineral is based on certain terms and conditions prescribed under the MMDR Act. Stop. The consideration for the grant of such permission is royalty, which in essence is the demand for parting with the privilege of working the mineral, para. It is immaterial whether royalty is designated as a tax. Stop. Any levy relating to mineral development, in so far as it is in relation to mineral rights, will serve as a limitation on the taxing powers of the state legislature. Stop. Taxes on minerals rights must be understood as such levies, charges, impositions or demands that are related to mineral development. Stop. Entry 50 cannot be a source of authority for imposing any levy, charge, impost, or demand which is either unconnected with mineral development or in relation to any other alien purpose, such as education cess, para. In view of the aforesaid discussion, I find that the learned Attorney General is right in contending that the Act contemplates all manner of levies, charges, impost or demands that could be provided for having a nexus with mineral rights. Stop. Therefore, the Act itself has to be construed as a limitation on the power of the states to demand or impose levies to the extent to which is stated in the Act. Stop. The submission that entry 50 is sui generis because it is the only legislative entry which limits the taxing powers of the state legislatures by reference to a general law, is a correct submission made by the learned senior counsel. Stop. The majority decision in Kesoram is a serious departure from the law laid down by the 7-judge bench in India Cement. Therefore, the said majority judgment is overruled. Stop.